Pull over. Engine off. Hands on the wheel. You have done everything right. You have your license. You have your permit. Your firearm is legal, stored correctly, and you have never broken a single law in your life. And in 30 seconds, none of that is going to matter unless you know exactly what I am about to tell you. Because there is a decision sitting in the United States Supreme Court right now with your name on it. A 9-0 ruling. Every justice, no exceptions. And if you keep a gun in your car and you do not know what this ruling says and what it does not say, the next traffic stop you go through could end your life as you know it. Not because you are a criminal, because you did not know the rules just changed. My name is Ray. This channel exists for one reason: to put the information in your hands before you need it, not after. Hit subscribe right now because this ruling affects every single gun owner in America who drives a car. That is not an exaggeration. Stay with me. Here's what happened. For years, courts across this country had been quietly building a legal argument that should terrify every responsible gun owner. The argument went like this: guns are dangerous. A gun in a car creates risk. Therefore, when an officer pulls you over and discovers you have a firearm, that firearm alone gives him the right to search your entire vehicle. No warrant, no additional evidence, no other reason, just the gun. Think about what that means in practice. You exercise your Second Amendment right to keep a firearm in your car. And the moment you do that, you automatically surrender your Fourth Amendment right to privacy. You cannot have both. You are forced to choose. That is what lower courts in multiple states were beginning to accept, and it was spreading until it reached the Supreme Court. On March 14, 2026, 9 justices looked at this exact situation: Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, Sotomayor, Kagan, Jackson, every corner of that bench, and they arrived at the same conclusion with zero disagreement. The mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. 7 words are doing all the work in that sentence. By itself, those 2 words are your protection and your trap at the same time. I will come back to that in a moment because this is where most gun owners get blindsided. The court was direct. Armed does not mean criminal. Legal carry is not evidence of a crime, and law enforcement cannot treat your constitutional right as a reason to violate another constitutional right. Your Second Amendment and your Fourth Amendment stand together. You are entitled to both at the same time. No conditions, no trade-offs. That is what 9 justices agreed on, unanimously. That never happens, not on anything touching guns and police authority. When it does happen, you pay attention because it means the line being drawn is not subtle. It is not going to be relitigated in lower courts. It is settled. Now, here is where I need you to lean in, because the ruling protects you only if you handle the stop correctly. And most gun owners are handling it exactly wrong. There are 3 traps built into this ruling that almost nobody is talking about. Trap 1. This ruling only protects legal possession. If you are a prohibited person, if you have a felony on your record, a restraining order, any disqualifying factor at all, this ruling does nothing for you. The gun in your car is not a neutral detail. It is evidence of a crime, and the officer needs nothing else. This protection is only for people whose legal status is completely clean. Trap 2, legal gun, illegal storage. Every state has specific laws about how a firearm must be kept inside a vehicle. Some require it to be unloaded, some require a locked container. Some restrict exactly where in the car it can be located. If an officer looks through your window and sees your firearm stored in a way that violates your state's storage law, the 9-0 ruling does not apply. He is not searching because of the gun. He is searching because he observed a specific criminal violation. The gun is legal, the storage is not, and that difference will cost you everything if you do not know your state's exact requirements. Learn them tonight before you drive tomorrow. Trap 3, by itself. Remember those 2 words. The ruling stops a legal firearm from being the only reason for a search. It does not stop officers from using it as one piece of a larger picture. You get pulled over, you have a legal gun, but your hands are shaking. Your story about where you're going changes twice. There is a smell coming from the back seat. The officer is not going to say he searched because of the gun. He is going to say the gun combined with the nervous behavior, the inconsistent answers, and the smell collectively created probable cause. And he may be legally right. The ruling did not touch the automobile exception to the Fourth Amendment. It stopped one specific thing, a gun alone. The moment other factors are present, the analysis changes, and it changes fast. So now let us talk about the actual traffic stop, because knowing the ruling is only half of it. The other half is knowing exactly what to say and what never to say the moment those lights come on behind you. Most gun owners think they have two choices when an officer asks about their firearm: tell the truth or lie. Both of those options, executed the way most people execute them, are disasters. Lying first. You panic. You say, no, there is no gun. You think the stop ends there. Here is what you have just done. In most states, making a false statement to a law enforcement officer is a criminal offense on its own. It does not matter that your gun was legal. If that officer develops any reason to search your vehicle and finds that firearm, you are no longer dealing with a traffic stop. You are facing obstruction charges, false statement charges, and your legally owned weapon has just become evidence against you. Lying hands the prosecutor everything he needs. Now, full honesty. You say, yes, officer, I have a firearm. Here is my permit. You think cooperation fixes everything. Here is what actually happens. You have just told a trained officer there is a weapon in the car. His entire body chemistry changes. His training kicks in. This is no longer a routine stop. This is what their protocols classify as an armed encounter. He will ask you to step out. He may place you in handcuffs for officer safety. He will ask to hold the weapon. He will ask where you are coming from, where you are going, what else is in the car. Every answer you give from that moment is raw material. You tried to do the right thing and you handed him an investigation that never needed to happen. So what do you actually say? 2 steps. This is it. Step 1. The officer asks about your gun. You look at him calmly. You stay completely relaxed and you say these exact words: Officer, I do not consent to any searches. That is it. You have not lied. You have not confirmed or denied anything. You have not been rude or combative. You have used legally precise language that invokes your Fourth Amendment right in a way that every officer is trained to recognize. That one sentence communicates everything. You know your rights. You are not giving consent. Any further search requires actual legal justification. The fishing expedition stops right there. He will push back. Officers are trained to push back. He will say, if you have nothing to hide, why not just let me look? Do not engage with that. Do not argue. Do not explain yourself. You do not owe anyone a justification for exercising a constitutional right. Stay quiet. Hold the position. Step 2. Immediately follow with one question of your own. Officer, am I being detained or am I free to go? This is your legal checkpoint. If he says you are free to go, thank him and leave. You won. If he says you are being detained, one final sentence. Officer, I am invoking my right to remain silent and I want to speak with a lawyer. Then you stop talking completely. No more answers, no more explanations. The conversation is over and you have given a prosecutor absolutely nothing to work with. Now the piece that will catch you off guard if you drive across state lines: duty to inform states. 11 states in this country require you to proactively tell an officer you have a firearm the moment any official encounter begins, not when asked. Proactively: Ohio, Michigan, Texas, Louisiana, among others. In these states, the script I just gave you gets you arrested. Silence is not protected. Silence is a crime. If you are in a duty to inform state, the moment the officer reaches your window, you say this: Officer, I want you to know I am a permit holder and I have a firearm in the vehicle. Then you stop. You have done exactly what the law requires, nothing more. If he then asks to see the weapon or secure it, you go straight back to the original script. I do not consent to any searches. Am I being detained or am I free to go? In states like Florida, Georgia, and Virginia, where there is no duty to inform, you have zero legal obligation to volunteer anything about your firearm unless you are directly asked a question you cannot honestly answer without mentioning it. Most Americans drive through multiple states without knowing which rules apply where. That assumption has put innocent licensed gun owners in handcuffs, not for violence, not for crime, for not knowing. Here is your action list before this video ends. Look up your state's duty to inform law tonight. Look up your state's vehicle storage requirements tonight. Write these 2 sentences in your phone right now. I do not consent to any searches. Am I being detained or am I free to go? Say them out loud until they are automatic, because under pressure with lights flashing in your mirror, the words you have rehearsed are the only words you will actually use. The Supreme Court ruled 9-0 in your favor. 9 justices who agree on almost nothing agreed on this. Your right to carry and your right to privacy stand together. You do not have to choose between them. But that ruling only works for you if you know how to activate it. And now you do. Subscribe, turn on notifications, because when the next ruling drops that affects what happens at your next traffic stop, you will hear it here first. Drop a comment below. Tell me your state and whether you knew about duty to inform laws before today. I read every single one. Stay sharp, stay legal. And the next time you get pulled over with a gun in your car, you will know exactly what to do.